Injuries involving third-party payers. Medical insurance with auto-related injuries. If you have been in an automobile accident and seek medical help, chances are your medical insurance will not cover your bill. In these cases, the auto insurance is responsible for the bill. However, it could take months or years to receive a settlement payout to cover those medical bills. The best course of action to prevent you from going into debt is to talk to your regular medical insurance about your accident and injury. They will report this to their subrogation department and should be able to make advanced payments to cover your medical expenses, meaning they will continue to pay medical services like normal, and when your auto insurance case has settled, your medical insurance will then ask you to pay back the money they paid your doctors. You will use the settlement money to repay your insurance, but if you don't report the accident details, they may deny payment and you will be stuck with the full bill. Typically, insurances will mail you paperwork called a third-party liability questionnaire. This is what you would fill out if you have been in an accident, whether auto-related or work-related. In fact, your insurance may require the paperwork to be filled out regardless of whether you have been in an accident or not. This could be triggered by you receiving a particular service that is often related to an injury. So if you receive something from your insurance regarding accident details and you have not been in an accident, don't throw it away. Fill it out and send it back to your insurance. Your insurance will deny payment to services if they do not have this paperwork on file. Now, let's talk about work-related injuries. This section of the video is directed toward a provider's office that may not be familiar with how it works. Medical insurance with work-related injuries. Workman's compensation is actually quite simple. You need the patient's date of injury and related body parts to that injury. Any services performed for those body parts are covered by workman's compensation. Anything outside of those body parts are covered by regular medical insurance. But before you start billing for services, always make sure you have an approval from workman's compensation based on your specific state's laws. If the workman's compensation is operating based on another state's laws, as a suggestion and not a requirement, attempt to talk the adjuster into operating based on your state's laws, as you will likely be more familiar with those laws than another state's laws. And as another helpful suggestion, if your medical practice encounters too many problems with workman's compensation, instead of refusing to accept the insurance, shop around for an attorney in your area that specializes in workman's compensation law. Many of these attorneys will work with your medical practice for free. They take claims that have failed to pay out and file a lawsuit against the workman's compensation company. Rarely do these cases go to court. Generally, workman's compensation will respond quickly by paying those claims and will be required to cover your practice's attorney fees. Utilize the attorney for denied claims only. But let's say workman's compensation has notified the medical practice that payments have been halted, but the injury case is still open. What exactly does this mean? It typically means the claimant or patient may have entered into a period of settling their case with workman's compensation, but do not automatically assume the case has closed with workman's compensation. Settling the claimant's case can sometimes take months or years. And if the medical provider agreed to accept the patient's workman's compensation, then the provider also agreed to abide by the state laws for that workman's compensation. This typically means you may not be able to legally bill the patient or send their account to a collection agency if the settlement takes a long time. So check your state laws before deciding to take that action over waiting on the case to settle. Once the case has settled, be sure to obtain the termination date of the workman's compensation plan from the adjuster on a company letterhead. Then talk with your patient on how the case has settled. Settlements can vary from the patient receiving a lump sum from workman's compensation, in which you can then bill the patient, or a lump sum could have been placed into a Medicare set-aside account, in which you can then bill Medicare. If the practice continues to treat the patient after workman's compensation has ended, be sure to let your patient know they are responsible for updating the workman's compensation information with their regular medical insurance. This may go beyond a simple phone call from the patient, as some insurances may require additional paperwork to be filled out by their members. Now, if the patient indicated they updated this information with their regular medical insurance, but the insurance continues to deny coverage citing a work-related injury, you may be able to appeal the denials with a copy of the adjuster's termination letter. If you decide to try this, keep in mind these appeals will be forwarded to the insurance's subrogation department, and receiving an outcome for that appeal may take longer than standard appeals. If the delay takes too long and the insurance indicates an allowance to bill the patient, the best course of action may be to bill the patient while waiting. This will force the patient to contact their insurance and fix any internal issues with them. Remember, the medical plan belongs to the patient, not the doctor, and it is ultimately the patient's responsibility to coordinate their medical coverage. Please like and subscribe if this information has been helpful to you. Thank you for watching.